My Lordship, I beg to mention one WBC criminal for motion, my Lordship, on 25th of this month. Okay. Deeply obliged. Give me the witness.
May I please, Your Lordships? Your Lordship, I beg to mention one WPC civil for listing, Your Lordship.
Please give to the courtmaster. All praise for listening. Please give to the courtmaster. I would like to mention for listening. Listening, please give it to the courtmaster.
Item 1 for motion.
May it pleases Your Lordship.
Yes.
Lordship, on the last occasion, Lordship, records were called for.
Lordship, there's an office note, Lordship. I just checked. The records of this case has already been sent in another matter, WPC, Lordship,
46. 46.
7746 of 2019.
Yes.
The
Yes,
same
Lord,
have been sent and communication by the FT member is also there.
Lordship, may I submit? I think in the ex parte order, Lordship, there are 3 persons been declared as foreigner.
Since the records are
Illeg-
there, tag it with that record. We'll get
Yes, Lordship. Yes, Lordship. But I humbly pray, Lordship, he is behind the bar for last 321 days. If IA may be allowed, Lordship.
Okay, let us have the record first. List this matter. Tomorrow,
Lordship will
20.
tag it with 777.
6/2025, along with the records of WBC 7746 of 2019.
19.
My Lord, date may be fixed if possible before vacation, Lordship. I humbly pray.
Tomorrow.
Oh, tomorrow, Lordship.
Difficulty.
Yes, Lordship. Actually, I'm traveling, Lordship. Can it be on day after tomorrow, Lordship? On
Okay.
25th?
25th.
Deeply obliged, Lordship. Deeply obliged.
Item 2
May I please, Your Lordship? This is an inter-party case, my lord. And the impugn order at page 61, my lord, annexure 13.
25th.
Page number? Page number 61, my lord. 16. Annexure 13. my lord.
I prove this.
Contested case, my lord. The father of the petitioner is Abdul Qadir. Grandfather is Alimuddin. my lord. His opinion of 98. My lord? Oh, no, 3524. Okay. 3524. Okay. He filed on 2nd of January. Learned counsel for the petitioner. You have missed the bus for a few days. My lord. Okay, certified copy you got on 7/9. Yes, ma'am. Okay. Okay. The respondents are there. Mr. Islam on behalf of AI Ali. Page 61 is the opinion. 35/2024. This is the Learned Counsel for the petitioners has submitted that the certified copy of the order was received on 7/9/2024. Therefore, some notice extra copies within 2 days. Yes, we got a Morigaon. Extra copy. Let the relevant records be called for. The prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in the application, bail of rupees 5,000, 10 days time to take bail, rupees 5,000 to the satisfaction of
SP Border Morigaon.
SP Border Morigaon.
I'm deeply available.
Item 3,
May I please, my lord, impute the order on page 81, my lord. My lord, the parents of the petitioner enrolled their name in the voter list of 1966 and.
You have to wait for some time for bail. This is 2/2/24.
My lord. My lord,
Strict. KM Hassan, and counsel for the petitioner. Respondents are there. Page 81, 2/2/2024, passed by so and so and so and so. The police reference case number so and so, declaring the petitioner to be a foreigner post 25/3/1971 street. Notice returnable on
25/7.
25/7/2021, extra copies within 2 days. Let the relevant records be called for from the concerned tribunal. The prayer for bail shall be considered on receipt of records of the tribal. List on 25/7/2021.
my lord, my name be shown in pause list, my lord. My name not shown.
It's not there?
No.
Okay. The list shall reflect the name of Mr. KM Hassan, learned counsel for the petitioner, along with other counsel on record, for listing the matter next.
My-
Item 4,
Yes,
May please your lordship, imprint order is at page number 91, dated 3/2/2020, lordship,
3/2/2020.
2020.
Then you have to wait for some time for bail. Ms. H. Ahmed, learned counsel for the petitioner. The respondents are there. Page 91. Opinion dated 3/2/2020. Passed by so and so, FT case number so and so, IMDT case number so and so, there's a SP reference number so and so. By declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice return over 25/7/2021. Extra copies within 2 days, call for the records. Prayer for bail shall be considered on receipt of records. List of 25/7/2025.
item 5,
Obliged.
Yes, Mr. Sandhya.
Matter was heard earlier, my lord. And the contention of the petitioner is that,
Okay, where is the opinion? Which page?
my lord. My lord, the input order at page 45. And this order goes to show that the petitioner was asked to file WS and documents. Whereas the contention of the petitioner is that there was no materials suspecting him as a foreigner in the inquiry report. In the first case, the petitioner filed a petition that there was no fair investigation. The inquiry report shows that he is untraced. So whatever information is given is, it cannot be said that as a,
Okay, what are the
result of
decisions you are
inquiry.
relying on?
my lord.
What are the decisions you are relying on?
My lord, my lord, we are relying on the decision, the full bench decision as well as the Supreme Court judgment in my lord, Sarvanda Sonwal 1. Sarvanda Sonwal 2, my lord. Sarvanda Sonwal 2, paragraph 60 says that the state has initial onus.
Page,
Well-
paragraph
Paragraph 60,
60.
yes, my lord.
And second one, Muslim Mandal.
Muslim Mandal, paragraph 97 and 98. Then, my lord, the recent judgment of
Paragraph?
my lord, Muslim Mandal, paragraph 97 and 98, my lord.
Okay. What is the,
My lord,
what is the
we are
proposition in
also-
Muslim Mandal?
My lord,
In Muslim Mandal, what was the proposition in this 97, 98?
my lord, I am reading, my lord. My lord, paragraph 97, fair investigation and fair trial being the basic fundamental human right of a person, which are concomitant to preservation of the fundamental right of a person under Article 21 of the Constitution. There has to be a fair and proper investigation by the investigating agency before making a reference to the tribunal. In such investigation, the attempt has to be made to find out the person against whom the investigation is made, so that the person concerned is given the opportunity to demonstrate that at that stage itself, and he is not a foreigner. In case the person concerned could not be found out in the village where he is reputed to reside or in place where he ordinarily resides or works for gain, the investigating agency has to record the same in presence of the village elder or the village headman or any respectable person of the locality, which in turn would ensure visit of the investigating officer to the place where such person ordinarily resides, reputed to reside, or works for gain, and making of an effort to find him out for the purpose of giving him the opportunity to produce the documents, etc., if any, to demonstrate that he is not a foreigner. The investigating officer, as far as practicable, shall also obtain the signature or thumb impression of the person against whom such investigation is initiated after recording his statement, if any, provided he makes himself available for that purpose. These are also instances. There are also instances where the person against whom such investigation is initiated changes his place of residence, maybe in search of livelihood or maybe to avoid detection. To ensure proper investigation and also having regard to integrity and sovereignty of the nation, once investigation relating to the nationality status of a person starts, he must inform the investigating agency in writing about the some change of residence, if any, thereafter. In case such person has failed to intimate the investigating agency in writing the subsequent change of his place of residence, the investigating agency has to mention the same in his report with his opinion relating to the status of such person on the basis of materials collected at the place where he earlier resided. That will ensure a fair investigation and submission of proper report on such investigation to the authority. Needless to say such investigation need not be detailed or an exhaustive one, keeping in view the nature of proceeding before the tribunal and the object sought to be achieved. Hence, it is need to be equal with an investigation conducted in criminal cases. Paragraph 98, my lord. The reference by the referral authority also cannot be mechanical. The referral authority has to apply his mind on the materials collected by the investigating officer during investigation and make the reference on being satisfied that there are grounds for making such reference. The referral authority, however, need not pass a detailed order recording his satisfaction. An order agreeing with the investigation would suffice. The referral authority also while making the reference shall produce all materials collected during the investigation before the tribunal, as the tribunal is required prima facie to satisfy itself about the existence of main grounds before issuing the notice to the proceeding. My lord, here, my lord, clearly said, my lord, that there shall be a fair investigation, giving an opportunity to demonstrate that he is not a foreigner by producing relevant documents. And here he is found untraced. So there was no scope at all to that, my lord. And there is no scope to say that he has left the place intentionally to avoid the detection. So in that view, my lord, and the tribunal is to, while issuing notice, is to satisfy based on the materials available before him. That was also not done, my lord. And my lord, in Sarvanda Sonowal 2 case para 60. My lord,
60.
my lord, yes, my lord. Para 60 has said that state has initial burden. One 140. My lord, the language of paragraph 15, my lord, I want to read, my lord. May I read, my lord?
Yes.
Having regard to the fact that the tribunal in the notice to be sent to the proceeding is required to set out the main grounds. Evidently, the primary onus in relation thereto would be on the state. This 3 lines, my 2-3 lines is very important, my lord. Tribunal has been is to set out the grounds in the notice, and therefore the state has the initial onus to collect materials of doubt. Merely on doubt, no case. That is the point, my lord. And my lord, the recent judgment of Rahim Ali case, the similar view has been given. My lord, in paragraph 34, my lord, in Rahim Ali's judgment, in our my lord, GLT citation is 2024 for SC 97, my lord. It is our GLT citation, my lord. GLT reporting. In para 34, my lord, may I read, my lord?
Yes. Yes.
My lord, para 34. However, the question is that does section 9 of the Act empower the executive to pick a person at random, knock at his, her, their door, tell him, her, they, them, we suspect you of a foreigner, and then rest easy basis section 9. Let us contextualize this to the facts at hand. The originating point of inquiry is the SPB Nalbari direction to the sub-inspector Datta on so and so. The pleadings and the records are silent as to what was the basis of SPB Nalbari's direction. What materials or information had come to his knowledge or possession that warranted his direction. My lord, read the paragraph again. However, the question is that does section 9 of the Act empower the executive to pick a person at random, knock at his door, her, their door, tell him, her, them, we suspect you of a foreigner, and then rest easy basis section 9. Let us contextualize this to the facts at hand. The originating point of inquiry is the SPB Nalbari's direction to Sub-Inspector Datta on so and so. The pleadings and the records are silent as to what basis this SPB border Nalbari's direction. What materials or information had come to his knowledge or possession that warranted his direction. Obviously, the state cannot proceed in such a manner. Neither can we, as a court, countenance such approach. My lord, this is, my lord, the has similar, my lord, the principle laid down in Sarvanda Sonal in paragraph 60, that it merely on doubt you cannot suspect a person. That means that the suspect is basis on the based on caste, creed, and community, that he belongs to that community, so he randomly suspect. That cannot be. There shall be a material to suspect him. That material is never collected. Never collected in the given case, my lord. In the first time the notice was issued, say, based on a inquiry report of the border police, which goes to show that he was untraced. He was never given scope to produce documents. Even it cannot be said that he has avoided his residence or avoided the detection or identification process. That cannot be said. And how they can give information that what is my color, what is my fair complexion, my height, etc., without getting me in contact. That was given in the inquiry report. Then, my lord, the petitioner file application. After application, the tribunal has passed order directing for an inquiry, fresh inquiry, to ascertain the stream. And in that inquiry, the investigation report, my lord, the report was collected from some person. They have disclosed no materials against me. My lord, kindly have a look at my lord. My lord. So, my lord, my prayer is that let the record come. Kindly see, my lord, what is going on in the tribunal.
Lordship, let the records come, Lordship. Since my friend is asking for the records, let the records come, Lordship will argue the matter then. Whatever information is furnished, Lordship, that information goes into the inquiry report and then it is forwarded to the tribunal. So it will take a detailed hearing and we'll also come prepared with that, Lordship. It's a 2009 reference, Lordship, 2009 inquiry report, which my friend is challenging today with new facts. So let the records come. We'll also address this court on these issues.
My lord.
Where is the inquiry report?
My lord, first inquiry report at Annexure 2, my lord.
No,
Sorry, one.
page 48, there is a reference to inquiry, no, not 48, page 46, page 47.
Yes, my lord.
There's a reference to
Yes.
inquiry report, which is that one.
Yes, my lord. The inquiry.
Page 47, there is a reference to inquiry report. Where is that inquiry
My
report?
lord, the statement of these witnesses are enclosed in the petition, my lord.
The
No, no.
inquiry report, Lordship.
There is a reference to inquiry report. A statement will not be an inquiry report.
My lord.
Where is that?
My lord, that in the inquiry report, SPB has stated that the opposite party, namely Shonsa, illegally entered. Yes, my lord, that report is Annexure 44, my lord.
Page,
Page 44, my lord, Annexure 8.
page 44.
and documents were collected only in this year, May, Lordship. The inquiry report is of 22/5/2025. During the course of investigation, Lordship, he visited the village Gaobura and found that the suspected foreigner, namely so and so, was staying at his own house. In this regard, he also collected some documents.
This one incorrect for this.
And after verifying the same, it has been found that one legacy data code of so and so, of namely Chabed Ali, was found, but here is not mentioned in legacy data which was submitted by the OP Sahajmal Ali as a grandfather. Further, upon checking his lineage documents like voters list in the year 1985-12, his grandfather's name recorded Chabar and Chabed Ali. So it has come to light that OP Sahajmal Ali illegally entered India after 25/3/1971. Statements of the following persons were recorded. On the basis of this, the tribunal has proceeded with the trial, Lordship. Just to stall the process, a new proposition has been brought up by my friend. Another few years will pass by, Lordship. So Lordship will take this up for hearing, and we will also come prepared with it, Lordship. 2009 inquiry, we are already in 2025.
My lord, how the police has inquired subsequently, I have stated in paragraph 6. Police suddenly
That is
visited.
his perception, Lordship. That is his
No,
assumption.
just a moment. Don't please,
Please
both of you don't submit together.
sit down, Lordship. Let my friend argue.
What is the name of your father?
My lord, his father's name. His father's name is Taiz Ali. Late Taiz Ali.
Where does his name appear in the first voter list?
My lord, voter list. My lord, I have annexed, my lord, 1959 voter list showing the grandfather's name or other paternal uncles. Then, my lord,
Which page?
orange milano this is ulta ulta. Then, my lord, 66 voter list. 70 voter list also, and 77 voter list contains the father's name.
Finally to 77. Shabir Ali grandfather. Okay. 27. 26. Petitioner to protect her. Five million. Yeah. 77 up to 97 after 20 years. Nine of one, really, but then there's one not one, really, not one. You see now. Yeah. This of the five hundred. Total receiving this month 22 years of education. Divide this. 97 lot. 26.
Okay, we'll examine and pass orders.
Right. Development.
Lordship, in the voters list, I would just like to point out after 1977, the next voters list is after 20 years, 1997. So the first voters list in the father's name doesn't appear. They are from the same village. And
First
after
voter
that,
list is of the year.
sorry,
First voter list is of the year 77.
no, the first 59. 59, some great grandparents, then 70, then 77. After 77, it is 1997. And the village changes from here, Lordship.
He has an explanation. He says that there was a erosion and therefore family shifted to from so and so to so and so. That in the
Yes.
repression he has said somewhere.
Maybe their Lordship.
Mm.
Then after 1997, 2005 and 2005 to 2015. But the basic link, his mandatory link has to be shown prior to 71, Lordship, which is completely missing. Only the names are there, Lordship, and extracts of the voters list is there, which is not admissible piece of evidence. They are not the certified copies.
My lord, we have
We'll-
approached this court. my
We'll
lord.
both examine the records of the afternoon and then we'll.
But nobody is ready with all documents, my lord. He used to collect and copy, my lord. That process is going on, my lord.
You understand?
Item 6.
Chamber.
Next to me now.
Yes.
Page 49, my lord, impugned order 1424.
49.
You just missed the bus.
My lord,
You just missed the bus.
I would be
Okay.
grateful if I am not allowed to miss.
No, we won't change the pattern. It gives us
My lord, the
difficulties.
date may be fixed, my lord.
We'll give a fixed
My
date,
lord.
25/7.
My lord. Not to be deported, my lord.
Okay, let's
Yes.
give that protection. In, uh,
She's outside.
So A.W. Amal and counsel for the petitioner, respondents are there. Opinion at page 49 by so-and-so, FT case number so-and-so, IMDT case number so-and-so. They were declaring the petitioner to be a foreigner of post 25/1970 stream. Notice returnable on 25/7/2025. Extra copies within 2 days. Let the relevant records be requisitioned from the concerned tribunal. Prayer for bail shall be considered on receipt of records. Next para. In the meanwhile, if the petitioner is apprehended, she shall not be deported out of the country without order of the court. List on so-and-so. 25/7.
Grateful.
Item 7.
May I please, your lordship? Lordship may kindly pass over the matter for time being. My senior is on legs.
Impugned orders of 27/9/24, Lordship.
Which page?
Page
Oh.
39, lordship. Page 39.
39. 27/9/24. Then you give her production. Your name?
Ms. D. Bora, on behalf of Mr. M.U. Mahmood.
D. Bora.
D. Bora.
Learned counsel appearing on behalf of Mr. M.U. Mahmood, counsel for the petitioner on record. The respondents are there. Page 39.
It's a no.
Opinion dated 27/9/2024. Passed by so-and-so in FT 8 case number so-and-so corresponding to so-and-so. Declaring the petitioner to be a foreigner of post 25/1971 stream. Notice returnable in 4 weeks, extra copies in 2 days. And the relevant records be called for. Prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in the writ petition, 10 days time to take bail, 5,000 to the satisfaction of.
Gwalpara, Lordship.
SP border Gwalpara. Okay.
Item 8.
You had that prayer. You had made a prayer to defer the matter for some time. I forgot about the prayer. You made a prayer to adjourn it for some time.
Yes, lordship. My senior is on legs.
So what should I do? Should I recall it and pass it over for the time being? No. Okay. Yes, item 8,
Against the impugned opinion dated 21/5/2024 now.
page
Page 17/179.
71.
17.
17. Okay.
Mile.
You have to wait for some time for bail. You are delayed by some days. Heard Mr. J. Laskal and the counsel of the petitioner. All the respondents are there. Page 16, opinion dated 21/5/2024. Passed by so and so in FT case number so and so, reference case number so and so. They were declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice call for the notice to download 25/7/2025. Extra copies within 2 days. Let the relevant records be requisitioned from the learned tribunal. Prayer for bail shall be considered on receipt of records.
My lord, only
Next, in the meanwhile, if the petitioner is apprehended, she shall not be deported out of the country without order of the court. List on 25/7/2025.
she may not be deported.
Pass the
Obliged.
button.
Item 9.
May please your lordship. Here, my lord, the petitioner once declared not foreigner, subsequently in a press proceeding by the impugned order at page 54 has been declared foreigner. So the principle of jurisdiction we have taken here.
So here, Sigdat, learned counsel for the petitioner. The respondents are there. Page 54, opinion dated 3/1/2025. Passed in so and so, police reference case number so and so. Declaring the petitioner to be a foreigner of post 25/3/1971. Notice extra copies within 2 days. Call for the records. Prayer for bail is opposed by the standing counsel for the FT matters. Considering the projection made, 10 days time to take bail of rupees 5,000 to the satisfaction of
SPB Dhubri,
SP Border Dhubri.
deep level.
Item 10.
4 weeks return.
My lord, in 10, the impugned opinion at page 93.
Second round of litigation, lordship.
February 2024.
Okay, here it is. Page 93. Mr. A.R. Sigdat. Dated 21/2/2025. Passed by so and so in application number is there. There's an IMDT reference in paragraph 1.
My
I've underlined it. Same order, notice extra copies, bail or this 10 days time to take bail or this 5,000 to the satisfaction of
SPB Borpata,
Superintendent of Police Border Borpeta.
deep level.
11.
ৰেকৰ্ডটো বেলেগ এটা কেছৰ লগত দিছে সেই কেছটো ইয়ালৈ টাইপ কৰাই দিছে কেছ নম্বৰটো আছে পিটিশ্যন লিখি থৈছো ওকে এটা কৈছে ৰেকৰ্ডটো উঠাই দিছে তাই তেতিয়া কৈছে নিজে দিছে আছে
May please your lordship. Impugned
Opinion is at which page?
page number 35, lordship, annexer 1.
35. Okay, 25/7/24. Mr. M. Amit and counsel for the petitioner. Respondents is there, Ms. N. Bedi. Opinion dated 25/7/2024. Passed by so and so in FT case number so and so. Corresponding to FT case number so and so. The petitioner to be a foreigner post 25/3/1971 stream. Same notice extra copies within 2 days. Call for the records. Bail of rupees 5,000 to the satisfaction of
SP border Nagaon.
Spirit of Police, Border Nagaon. 4 weeks notice.
Highlight.
Item 12,
Yes, which page is the opinion?
Page 90. 90.
90. Okay. Your name?
S. Hussain.
S.
Hussain.
Hussain and counsel for the petitioner. Respondents are there, Ms. N. Bedi. Opinion dated 24/12/2024. Page 90. Passed by so and so. In FT case number so and so, SP. SPB case number so and so. Declaring the petitioner to be a foreigner post 25/1971 stream. Notice extra copies within 2 days. Same prayer for bail is opposed by the Honorable 20% of 30 matters. 10 days time to take bail of rupees 5,000 to the satisfaction of
SP border Nagaon.
SP Border Nagaon. This stuff for 4 weeks on the city of records.
13,
Yeah, please, your lordship. Your lordship, this court may not like to take up this matter, your lordship. And as there is an urgency, your lordship, can the matter.
Is the matter be not before any other bench
Lordship.
without one of us? K.R. J. Say that is urgency expressed. The registry shall list the matter before list the matter on. Make it tomorrow.
If it is on tomorrow, your lordship, tomorrow, your lordship,
We are fixing it tomorrow, 24.
deeply obliged.
item 14,
My lord, page number 17 impugned order, my lord. 14/7/21. 17.
Petitioner respondents are there, Mr. Kuli on behalf of AI Ali. Opinion dated 14/7/2021. Passed by so and so in FT case number so and so, D case number so and so. They were declaring the petitioner to be a foreigner post 25/3/1971 stream. Keeping the issue of maintainability open, issue notice returnable on 25/7/2025. Extra copies within 2 days. Let the relevant records be requisitioned from the concerned tribunal. The prayer for bail shall be considered on receipt of records. List out 25, 3, 1971. Sorry, 25, 7, 19, 22, 2025.
Great.
Item 15.
Yeah, please, your lordship, my lord. My opinion is a page number 47, my lord. We have an order of passed on 31/5/2024, and a copy was received.
Yes, Mr. Boro, you,
Copy
from
of,
tax you are here.
my lord.
From tax you are here.
My lord, I'm taking for tax only in Itanagar, my lord.
Okay. Here, which page is the opinion?
47, my lord.
47.
Copy was obtained on 19/11/24, my lord.
But since you have crossed 1 year, you will not be deported. Your bail will be considered on receipt of records. Heard Mr. M.K. Boro and counsel for the
But
petitioner.
here the little thing is that the notice was not issued to the petitioner, in fact, it was issued in the name of Sahanara Begum. And it was reflected in the notice itself. But the process server said that
Where is the notice?
at page number, my lord, 20, my lord,
Page number?
20, my lord. And the vernacular is at page number 21, 21B.
Just on. Yes, Sahanara Begum. Then
Page number
process
20
service report is page 22. Type page is at page 21A.
my lord.
Yes. Page 21A. Look at the English. Assamese one is at page 22.
Not served. Not served. Only 50%.
Then we give her protection. If this is so, reference can't be altered like this. Okay. Yeah. Mr. Ankaboro, counsel, the respondents are there, Mr. AIRE or the ECI. Opinion dated. Mr. Take the form from, listen, take the form from my secretary. Right? It will be in the same format, the others. Page 47, opinion dated 31/5/2024. I've tick marked, passed by so-and-so in FT case number so-and-so, SP case number so-and-so, declaring the petitioner to be a foreigner post 25 through 1971 stream. Notice. So just before that you say, before notice you say, the Learned Counsel for the petitioner has submitted that as per the foreigners, as per the notice, the tribunal's notice was issued on 1 Musammat MUSSTT Sahanara Begum SAHNARA Sahanara Begum, and when the process server came to the house of the petitioner, she informed the process server that she is not Sahanara Begum but Hasna Khatun, HASNA KHATUN, and therefore the notice was served on her. Notice returned within 4 weeks. Extra copies within 2 days. The learned standing counsel for the FT matters has opposed the prayer for bail. Considering the projection made in this writ petition, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Nagaon. List after police on listed to records.
File acknowledgement.
Item 16,
Yeah, please, your lordship. My lord, the opinion at page 84, my lord. Yes, madam.
You have to wait for some time for bail. Mr. S.A. Ahmed, learned counsel for the petitioner. All the respondents are there. Ms. N. Bedi on behalf of Ms. P. Barwa, for CI. Opinion is at page 84, dated 22/1/2024. Passed by so-and-so in case number so-and-so, police inquiry number so-and-so. They were declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice returnable on 25/7/2021. Extra copies within 2 days. Let the relevant records be requisitioned from the concerned tribunal. Next, the prayer for bail shall be considered on receipt of records. In the meanwhile, if the petitioner is apprehended, she shall not be deported out of the country without order of the court.
Obliging.
17,
My lord, in this case, my lord, the opinion at page 123, my lord.
123.
Yes, ma'am.
Okay. Mr. S.A. Ahmed, learned counsel for the petitioner. All the respondents are there. Ms. N. Bedi on behalf of Ms. P. Barwa. Opinion is at page 123. Opinion dated 27/2/2025. Passed by so-and-so in case number so-and-so, police inquiry number so-and-so. Thereby declaring the petitioner to be of foreigner post 25/3/1971 stream. Notice returnable in 4 weeks, extra copies within 2 days. Prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection, 10 days time to take bail of rupees 5,000 to the satisfaction of
My lord, SP Border, Shivsagar.
SP Border,
Shivsagar.
Shivsagar. Okay. List after 4 weeks or receipt of
Obliged.
records.
eighteen,
Yes,
Page 19.
90
19.
19. Okay. Your name? Mr. P. Boyragi, learned counsel for the petitioner. All the respondents are there. Ms. N. Bedi. Opinion is at page 19, dated 24/1/2019, passed by so and so in case number so and so, corresponding to SP inquiry number so and so, by declaring the petitioner to be a foreigner of post 25/3/1971 stream. Next paragraph, keeping the issue of maintainability open, issue notice returnable on 25/7/2025. Extra copies within 2 days. If prayer for bail shall be considered on receipt of records. Next paragraph. List on 25/7/2025.
Item 19,
Please, your lordship. Chief imprint order is at page number 98 to 109 dated 19/3/2021.
Yes. Page number
98, lordship,
98.
dated 19/3/2021.
21. Okay, you
21.
have to wait for some time for bail. Ms. H. Ahmed and counsel for the petitioner.
Nalbari.
Pardon me?
SPB Nalbari. SPB Nalbari.
No, we are not giving a protection. You have to wait for some time for bail. Ms. H. Ahmed and counsel for the petitioner. Opinion is at page 98. Dated 19/3/2021. Passed by so and so in case number so and so, IMDT case number so and so. There's a third reference, SPB reference number so and so. Thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. Next paragraph, keeping the issue of maintainability open, issue notice returnable on 25/7/2025. 25/7/2025. Extra copies within 2 days. The prayer for bail, let the relevant records be requisitioned from the concerned tribunal. Next, the prayer for bail shall be considered on receipt of records. List on 25/7/2025.
20,
May I please, your lordship? Page 106 is the impugned order, my lord. Annexure 20, my lord.
106.
106, my lord. Opinion was rendered on 26/12/2024, my lord.
Mr. Z. Hamad, learned counsel for the petitioner. Page 106.
Yes.
Opinion dated 26/12/2024. Passed by so and so in case number so and so, police inquiry number so and so. They were declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice returnable in 4 weeks. Call for the records. Extra copies within 2 days. The prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in this petition, 10 days time to take bail out of his 5,000 to the satisfaction of
SP border Morigaon, my lord, since he is a resident of Morigaon, my lord. The
SP border Morigaon.
Morigaon, my lord. The notice was also sent in Morigaon, my lord.
Okay.
My lord.
But at page 106, the reference is by SP border Jorhat.
SP border Jorhat, my lord. The notice lordship will find at page 51, my lord.
51.
Yes, my lord. And the vernacular is page 52, my lord. Since the notice, he is a resident of my lord Morigaon district, my lord. And the
Just-
notice
just a
was
moment.
sent in Morigaon. Botwal Kasharigaon, PS so district Morigaon, Assam. Therefore, my lord, I'm praying before your lordship, my lord, so that I may appear before the concerned Superintendent of Police Morigaon. my lord.
But they will not have records,
If
Ms. Verma.
necessary, I'll appear before the my lord Jorhat. I'll appear before the SP.
Ms. Verma, please clarify what will happen.
Jorhat Lordship, you were saying.
The, you, page 106, you have a copy, page 106,
Yes. SP's reference from Jorhat. my lord.
SP references by Jorhat.
Yes. So the notice was sent to my lord Morigaon district.
No, no, that will not give jurisdiction there.
Yes,
You will be in
I'll
difficulty.
appear before the my lord SP.
Jorhat,
Jorhat.
please, let's still check it, page 106,
Yes, my lord.
Yes,
If
I
that-
SP,
Lordship.
SP Jorhat.
Jorhat.
So they will have the records, not
Yes,
the
yes.
superintendent, okay.
Lordship, I may be allowed to rectify the minor mistake in the cost title, my lord. I'll put down, my lord, I'll write down the SP border Jorhat, my lord, instead of Morigaon, my lord.
Oh, then it has to be corrected first. Otherwise, the certificate copy will,
Right now, I'll correct it, my lord, by hand. my
no,
lord.
no, it can't be done. You know the, rule now,
Yes,
under the High Court rules, it has to be done there. Better do it, we'll take it up tomorrow.
yes, my lord.
We'll release this today only.
Lordship,
the-
I'll leave this by tomorrow.
Uh, okay, what we'll do is that we'll pass the order, but we'll give you liberty to correct it. But do
Yeah.
it, otherwise the certified copy will be delayed.
But I'll do it right now, my lord.
No, no,
We cannot, we have to. then make a
you
fresh
have to give a type
application.
copy. You can't do it
I'll-
right now.
Give a fresh type going.
I'll, even if I give you 10 minutes time, you'll not be able to do it.
My lord, I understand.
Lordship,
Mr.
possible order like.
Heard Mr. Zaid Ahmed, and counsel for the petitioner. All the respondents are there, Ms. N. Bedi. Next, at the outset, the learned counsel for the petitioner submitted that inadvertently, as respondent number 5, he has implemented the Superintendent of Police Border Morigaon,
Yes. Respondent
which
my lord.
should have been Superintendent of Police Border Jorhat.
Jorhat.
Full stop. Accordingly, the learned counsel for the petitioner is granted liberty to file amended cost title before the AOJ FT section so as to be incorporated in the cost in the writ petition. Next
Four,
para.
five, six, we did.
Respondent 456 needs
Yes.
correction.
4, 5, and 6, my lord, because
Not
4 is
deputy commissioner, district commissioner.
district commissioner, he should be from Jorhat, my
No,
lord.
but here there's a correction made. District Commissioner,
Not in my
4,
petition.
5,
It should be, my lord, Jorhat, my lord, district
Okay,
commissioner.
4, 5,
right?
6.
5, 6.
Similarity is submitted in the first that paragraph. It's submitted that the nomenclature of respondent number 4 and 6 are also incorrect. And therefore, on his period is strike it out. You write a fresh one. He says that at the outset, the learned counsel for the petitioner has submitted that there is a inadvertent error in arraying of parties as respondent numbers 4, 5, and 6. And therefore, he prays and is allowed to amend the cost title in respect of respondent numbers 4, 5, and 6 by implementing the appropriate authority. Most of the same shall be done by submitting a freshly typed out copy of the freshly typed out cost title and hand it over to the AOJ within bracket FT section so as to incorporate the same in the record. Next paragraph. By filing this writ petition in Article 226, open is at page 106, dated 26/12/2024, passed by so and so in so and so, thereby declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice returnable in 4 weeks, extra copies within 2 days. The prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection, 10 days time to take bail out of this 5,000 to the satisfaction of Superintendent of Police Border Jorhat. Next paragraph. The issuance of certified copy shall be delayed till the amendment of the cost title. Next paragraph. List out of voice of the set of records. Deeply obliged.
Cycle 2516.
21,
Contested case, my lord. The imperial order is set case note 95, my lord. The father has been
Opinion at
examined as-
page.
Page 95, my lord. The father of the testimonial has been examined as DW2, my lord. So page 72.
Okay. Mr. S. Islam and counsel for the petitioner.
Opinion is 99.
99. Note, Master.
Opinion at page 95. Dated 9/9/2024. Passed by so-and-so in FT 8 case number so-and-so, corresponding to FT case number so-and-so. Thereby declaring the petition to be a foreigner of post 25/3/1971 stream. Notice returned in forms, extra copies within 2 days. Prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in the writ petition. 10 days time to take bail out of 5,000 to the satisfaction of
SP border Kualpara, my lord.
SP border Gwalpara. Okay. Please start with voice of records. Obliged.
22,
Please, your lordship.
Yes, Mr.
The
Ahmed.
opinion is at page number 36.
Page number
36, my lord.
36.
36.
Okay. Mr. A. Mohammed, and counsel for the petitioner. For the response to them, Ms. Mbedi. Opinion dated page 36, dated 27/9/2024. Passed by so-and-so in case number so-and-so, reference number so-and-so. Thereby declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice extra copies within 2 days. Call for the records. Prayer for bail is opposed by the learned standing counsel for the FT matters. Next paragraph, considering the projection made in this petition. 10 days time to take bail out of 5,000 to the satisfaction of
Superintendent of Police, lordship, Sonitpur.
Superintendent of Police Border, Sonitpur, Tejpur. They start of 4 weeks of receipt of records.
Hi, lord.
23,
Wait, your lordship.
Yes,
Here
Ms.
are the
Begum.
page
Page number
55, lordship.
55. That is T. Begum and counsel for the petitioner. Respondent Sajam is N. Bedi. Opinion is at page 55. Opinion dated 18/3/2025. Passed by so-and-so in BNGN case number so-and-so. Arising out of BNGN IMDT case number so-and-so. They were declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice extra copies within 2 days. The relevant records be requisitioned from the concerned tribunal. Next one. Prayer for bail is opposed by the learned standing counsel for the FT matters. So considering the projection made in this writ petition. 10 days time to take bail out of this 5,000 to the satisfaction of SP border Bangaigaon. Okay. This start of force and receipt of records.
Here, President.
item 24 for admission.
Before we start admission, we'll take a short break and come back.
It's coming back after the break. We have it over.
In the meanwhile, please see the records.
He's already been handed over, Lordship. We have the
Which-
instructions.
Reached home, my lord.
Hmm?
Reached home, but
Reached home,
my lord.
so you can close this matter.
The active,
No, the
petition
challenge
will
is there.
my lord.
The challenge is there.
Yeah,
Okay,
Only the IA will go if he has filed one.
File an
just
affidavit.
check the records in the meanwhile. Just take a break and come back.
My lord.
देखा घर भी भेज दिया तो
24,
There's an IA.
এইটো লাগি থকা নাই স্যার কোর্স লিষ্টত অহা নাই
আছে নেকি তাতে? Okay, there was no IA. We took it on the basis of an affidavit filed.
My lord, my lord.
Okay. Okay. Now, Merit, what is the best document you have? To
Uh,
connect you with your projected parents?
Can I argue later, my lord? Today it was for this instruction, my lord. Some other day, my lord. After vacation, my lord. He has reached home, my lord. Police
Hmm?
has safely kept it at home. my lord.
Okay. Mr. A.W. Amal, learned counsel for the petitioner, has submitted that pursuant to the order passed by this court on 13/6/2025, as per his instructions, the petitioner, namely, also the father of the petitioner,
It's a petitioner only. Petitioner, not petitioner. The son is the deponent, my lord.
in that affidavit.
My lord. Even in
Okay,
the
that
petition,
means the order was incorrect. There was an error in the order, that means. Okay, the petitioner, namely Hazrat Muhammad Hazrat Ali, alias Hazrat Ali, alias Muhammad Hazrat Ali, was detained on, when was he arrested?
26, my lord.
26/5/2025, pursuant to opinion dated 29/2022.
No, my lord, that the earlier detention was, my lord, it was on 22/9/2022.
No, now you were arrested when?
Yes, my lord. Now, because I was on bail. I was on bail by this honorable court. Despite that, I was arrested.
When were you arrested?
Recently, 26/5/2025.
26/25. The strength of opinion dated 29/2022, passed by the learned member, Foreigners Tribunal Jorat, in FTG, full stop, 135 of 2011, has been released and he has returned home. Next para. The learned standing counsel, Mrs. The learned standing counsel for the FT matters has produced a copy of a letter dated 26/2025, issued by the senior superintendent of police within bracket border, bracket close Golaghat, informing that the petitioner has been handed over to his family member on 19/6/2025. Next one. The said communication dated 26/2025, along with the copy of custodial bond enclosed there too is kept as a part of record. Next paragraph. On the prayer made by learned counsel for the petitioner, the matter stands adjourned today. List in the week commencing 22/7/2025 in the admission column. Who the respondents are there? Okay,
Grateful.
Item 25.
May I please, Lordship.
yes.
Yes, my lord. And we have a look at case, my lord, 38, expiry order, my lord. Case 38, my lord. Thirty-nine is the relevant portion.
Just a moment. The notice was served to your husband.
Yes, my lord, but what happened in this case, my lord, on various issues, my lord, there was dispute in between the husband and the petitioner, my lord. And in the year of 2020, my lord, she left her matrimonial home, but actually the petitioner, Fuljan Nessa, was also born and brought up at the same village, my lord, nearest, my lord. Husband house and the petitioner house is nearest, my lord, at the same village, my lord. I have annexed all the documents, my lord, of her parents, brothers, and other family members, my lord. Wherefrom it shows that, my lord, same village, my lord. But in the year of 2020, my lord, she left her matrimonial home, my lord. That's why, my lord, on that was most probably served.
But you see,
on the
unless
Mallard
unless you show that there was a divorce or
there's no divorce.
you
my
are
lord.
living separately, it can't be
My lord,
accepted.
recently, when my lord, the police have been searching, my lord, she came to know that an expiry order has been passed. And after coming to know the expiry order, she obtained all the documents from the, my lord. But otherwise, my lord, if there was, my lord, if she would have been aware, my lord, she definitely should have been contested the case, my lord. And her husband also never informed the petitioner, my lord.
It's just not believable.
My lord, otherwise, my lord, it's- it's kindly afford an opportunity, my lord, she will contest the case, my lord. And she has all the documents, my lord, her parents, brothers, grandparents, my lord.
This notice was served on your husband.
Yes, my lord.
That is on
That was
uh,
The notice was issued on second time of 29/12/21. My lord,
It was returnable before 3/6/2022. Correct.
yes, my-
Now, please show us a voter list where you are available with your own brother and family members in your parental home. Is there any voter list showing you in your parental home?
there's no voter list, my lord. But I have annexed one voter list of 2015, my lord. That was with her husband. That is page 52, my lord.
So after that, you are not in the voter list anywhere. After 2015, you are not in the voter list.
In 22, my lord, I could not, my lord, obtain the same, my lord. In 2022, her name was there in the voter list, my lord. But I could not annex.
You have a copy of you with you?
No, my lord.
Then you better bring it on record, otherwise we'll be dismissing this.
My lord, just
If-
kindly give an opportunity. Otherwise, my
No,
lord,
no, once
that
you
it-
see, you'll have to demonstrate that you are living separately from your husband. If there's no such
my
record,
lord, I have
it
never been
will
left.
be a false plea. This will be a false plea.
My lord, I have not lost any complaint against my husband. That's because, my lord, there are some issues, my lord, matrimonial issues, my lord. And there is, my lord, I have all documents, my lord. Let's see.
That's okay, but
Okay.
it's not a discretionary power we have. You have to demonstrate that they are, if you are, if the voter
That-
list
that
shows that you
never-
are living with your husband, then you don't have a case.
But my lord, I have never left the village, my lord. I'm still now residing at the same village, my lord. But the process server has never attempted to serve the notice to the petitioner, my lord. That's why, my lord,
Oh, under 3,
still
5,
now,
if it's permissible to send on the adult member of the family. If
But
you
my
can
lord-
demonstrate that your husband was not an adult, you save
But-
yourself. You have to
my
demonstrate
lord,
something. If you are there with your husband's in the marital home, then you don't have a case. You can't set it aside.
I have not lost any complaint against.
It's
my
okay. You
husband.
may not lodge it. We are not saying that
That's
it's
why, my lord,
necessary to
there's no
lodge.
any document, my lord. That's why I have
But if you have
stated.
left your husband, your
Yes.
name will be there in the next voter list. You don't say anything when you left the
Okay.
matrimonial home. Have you pleaded the date when you left the matrimonial home?
Date may be in the year of 2020, my lord. Here I have mentioned, my lord. The village women, my lord, from the remote area, my lord.
So if it is 2020, then there will be some panchayat election or something where your voter list will be there in your parental home.
Here, some, my lord.
Maybe because of the dispute, your husband wants you to be out.
There was some village mail, my lord, but whether any documents was there, I have no any instruction, my lord. That's why I have to obtain the instruction, whether any, my lord, village mail or something else, my lord, was there.
You have to show your separate residence. If you are there with your husband, then it's a story of convenience. Conveniently, you say that you are residing with your husband. Sometimes you say you are not residing with your husband.
My lord, since 2020, my lord, I am not staying with my husband, my lord. I am staying.
Then your
with
voter list must be there with somebody, with someone with
But-
whom you are residing.
But I am staying at the same village, my lord, nearest, my lord. Yes, because she was born and brought up at the same village, my lord. My lord, date may kindly fix, my lord. I will obtain the instruction whether any village mail or something else is there or not, my
Okay.
lord. Then I will file
All
the
sides are
affidavit, my
all
lord.
sides are represented. In the next, in this case, the learned counsel for the petitioner projects that due to some matrimonial dispute, the petitioner was not residing with her husband. You stop. Next, according to the query of the court as to what is the document evidence to show that the petitioner was not residing with her husband and residing with her own matrimonial family. Sorry, paternal family. The learned counsel for the petitioner seeks some time to obtain instructions and address the court. Next matter stands adjourned today. List on when?
After vacation, my lord.
List. List of the week commencing 28/7/2025.
Obliged, my lord.
Item 26.
Yeah, please, your lordship. Lordship, last date LCR was called for, but not received.
Which is the best document you have to connect you with your projected parents? Which is the best document you have to connect you to your projected parents?
LCR was not received.
Pardon me?
LCR was not received. I think in court list it was not so.
Huh?
LCR else.
LCR
will
not
come.
received.
Okay. Then send an email. Also as a represented. Next, as per office note dated 26/2025, comma, the traveler's records is not received. Next, accordingly, the registry shall send a reminder to the Foreigners Tribunal, Bangaigaon number 2nd, Abhyapuri, by email to send the records of page 56. Records of censorship decided by opinion dated 29/6/2019. Next, madam, awaiting production of records on a list on 24/7/2025. Okay, we're sending record by email.
Yeah.
Item 27.
The records have not come.
My lord, this is an expert order, my lord. The last occasion, records were called for. 73-year-old woman, my lord. Notice was not served. The case was during the COVID period.
73 years.
My lord.
Do you have the documents here, how the notice was served?
My lord, may I take your lordship to page number 18, my lord?
18.
Page number
Yes.
18, my lord, in the impugned order.
Brother accepted notice, my lord.
My lord, this is not the brother, my lord. The father's name is, can I read, my lord? Miss Perez?
Yes.
My lord. Accordingly, after registration of the case, notice was issued to the OP and accordingly notice returned with the service report. The service report of the process server dated 19/3/2020 stated that in pursuance to the notice, they went to the house of the address of the OP mentioned in the notice at the time of the service of the notice, the OP was not present in the house, and in absence of the OP, his brother, it should be her, brother Abdul Hai accepted the notice on behalf of OP Rohima Khatun. The process server took signature of the Gaubura Azizul Haq, son of Faraz Ali, and brother of the OP Abdul Hai, son of Sorab Ali. Now, the petitioner's father is Rohis, not Sorab. So it's not the brother. Said service report as the witness of the service of the notice upon OP that the date fixed for notice returnable on 19/4/2020. The case could not be taken up on 9/4/2020 due to national lockdown by the government of India for preservation of prevention of COVID-19 pandemic. Accordingly, the lockdown period, after the lockdown period, the case was taken up on 12/5/2020, and on that day, the notice of the process server was perused. And on perusal of the notice, the tribunal proceeded by an order that the notice was duly served under the provision of section 3(5)(b) of the Foreigners Tribunal. Now, this is not 3(5)(b), my lord. The 3(5)(b) says, my lord, it says if the proceeding is not found at the address at the time of the service of the notice may be served on any adult member of the family of the proceeding. Now, my lord, because this Abdul Hai is not the family member, so my humble submission is that 3(5)(b) has not been complied with. I will take your lordship further through this order that notice, though the notice was served during the lockdown period as the physical functioning of the tribunal was restrained by the notification of the Guwahati High Court by framing guidelines from time to time, that as physical functioning of the tribunal was restrained, the case could not be taken up on this date. Thereafter, on resumption of the physical function of the tribunal as per the guidance of the Honorable Guwahati High Court, the case was fixed on 16/1/2020 for WS documents and appearance of OP on 6/11/2020. OP remained absent without the stay. Thereafter, on the subsequent dates, that is these dates, the OP remained continuously absent. As a result, the case was fixed for argument. The state side, the OP preferred not to contest the proceeding despite notice was duly served upon her under the provision 3(5)(b) of the FT order. Now, during COVID, notice not served, 3(5)(b) not complied with. Considering the age, my lord, I may be granted.
But then what this person was doing in your house?
My lord, no, this is not my house, my lord. Not the notice did not come to my house. If had it come to my house, I would have received, my lord, or any family member would have received.
In presence of Gaubura, lordship, notice was served, lordship.
Is that process server report available? No.
My lord, it is. I have not annexed it, my lord. This is the only thing I have, my lord, the impugned order, which is detailed, my lord.
Considering the age, we give her some protection.
I know.
Not to be deported.
But not to be deported is already there.
Already
She
there.
may not be arrested also.
Right.
She's 73.
I know.
Okay. Mr. A.W. Ahmed, counsel for the petitioner. All the respondents are there. Mr. Islam. although, as per order dated 4/6/2025, although the requisition for records was sent by speed post as well as email, comma, the records of the tribunal is not received. Next, the learned counsel for the petitioner has submitted that the age of the petitioner is 73 years. And though she has been protected by order dated 4/6/2025 against deportation, but it presses the prayer for bail. Next, the learned counsel for the petitioner has submitted that as per the as per the contents of paragraph 2 of the impugn opinion, comma, the process issued to the petitioner was served on one Abdul Hai, comma, son of Sohrab Ali, which was served in the presence of the Gambura Azizul Haq, projecting the said person to be the brother of the petitioner. In this connection, the petitioner relies on copy of certificate issued by the Gaon Pradhan, in charge Gaon Pradhan, projecting that the name of the father of the petitioner, Rohima, Rohima, Rohima Bidwa, Bidwa, is late Rohis, Roj, Rohij Uddin. Accordingly, it is submitted that the person accepting the process was not her brother. And he reiterates that considering the age of the petitioner, which is 73 years, she was granted bail. Next paragraph. His prayer for bail is opposed by the learned standing counsel for the FT matters on the ground that the process is shown to have been duly served on the petitioner in the presence of the Gaon Pradhan. And as per the said opinion, the same was served on the brother of the petitioner. Next paragraph, be that as it may, considering the age of the petitioner to be 73 years, the court is inclined to grant bail to the petitioner, providing that those two conditions and prayer for bail, rupees 5,000, 10 days time to take bail of his father to the satisfaction of SP Border,
Barpeta.
Borpeta. Next paragraph, in HC shall issue a fresh reminder to the, not fresh, issue a reminder to the concerned tribunal for sending the records at the earliest. Next paragraph, list on. 24/7.
Grateful, madam.
Item 1. BA 626/25.
Last occasion, we have pressed for non-furnishing the grounds of arrest. In this regard, we have submitted an additional copy of the same furnished to the learned PP in the meantime.
When was it filed?
It's quite long ago. But learned PP contended that he has not received. That's why we have submitted again.
It's in the later part of this.
Okay.
We have annexed some of the observation of Honorable Apex Court of India.
Where is the document? Where is the arrest memo and
Yes,
The-
page number 36.
30?
In the additional affidavit. Page number 36.
36.
Yes, my lord.
Mr. Sharma, have you gone through the records? Is it, is the other, any other memo available?
No, Lordship.
Grounds of arrest?
Only that much, Lordship.
Only that much?
That much, what is there in the, what they have annexed, Lordship.
But you know, Mr. Sharma,
Lordship,
I think even in the Assam Police Manual,
Lordship.
there is a provision for grounds of arrest to be given. Let me show it to you.
Moreover, one of the quick was released on bail by the Honorable Learned Session Judge. No,
Oh,
there
that's
was
okay.
some
There were-
typographical error. In the meantime, that has been rectified by the learned session just Guwahati.
Fingerprint is by whom? The fingerprint is of which person?
The present petitioner which.
Present petitioner.
Yes.
Is
Orup Das.
Arup Das.
Moreover, there is a confessional statement of co-issues. She has not implicated at all. And she has been released on bail by the landed settlements. Hiramani Halal. We have annexed you, my lord. Case number 16.
The implication of co-accused is different footing. Your primary evidence is in a different footing.
Yes, my lord.
There are two eyewitnesses to the incident, Lordship. They happen to be the children of the co-accused. Their 164 statement has also been recorded. They have clearly implicated the present petitioner as well as their own mother, Lordship, for that matter.
Pardon me?
The eyewitness, Lordship, two eyewitnesses are there. They are the children of the other co-accused, Lordship. And Lordship, they, in their 164 statement, they have clearly implicated their own mother as well as the present petitioner of having committed the crime, Lordship. And if I may just point out, Lordship, the present petitioner also wanted to confess, Lordship, but at the last moment he declined, Lordship, from confessing, Lordship.
Full submission is that two minors already been examined. There is no chance of absconding as well as influencing the witnesses. And as per the observation of Honorable Apex Court, accused should not be treated as an accused till pronouncement of guilty. So we want to submit observation of Honorable Apex Court reported in 2012 1 SSC, Sanjay Chandra was a Central Bureau of Investigation. I may be read out the vital irrelevant portion. In bail applications, generally it has been laid down from the earliest times that the object of bail is to secure the appearance of the accused person at his trial by reasonable amount of bail. The object of bail is neither punitive nor preventive. Deprivation of liberty must be considered a punishment unless it is required to ensure that an accused person will stand his trial when called upon. The courts owe more than
You
verbal
see,
respect
Surendra
to
Kumar, this Surendra Kumar until I follow that.
any condition. I ensure that I shall appear before the trial court as and when required at the time of date fixed.
Lordship, I have also flag marked one order, Lordship, that is in the LCR.
I've read the evidence of the victim's son.
No, Lordship, this is on it regard to 4748, Lordship, order dated 26/6/24, blue flag mark, Lordship, only one
Yes.
blue flag mark, Lordship, when they were produced before the court below, Lordship.
Yes,
Yes, Lordship will find.
I peruse the ground of arrest.
Yes, and
Oh, no, this will not help you. The reason why I'll tell you. This always has a reference to section 165. 167.
167. CRPC.
That's page 1019. 1019. CRPC. You have CRPC?
CRPC. Lordship.
I put a pencil mark.
Yes.
And then look here. Grounds of arrest.
Yes.
Because this is the satisfaction. What happens is that the legislature was aware
Yes.
that perhaps the judicial officer will not have time.
Lordship.
Therefore, what is required is that when you are forwarding an accused before the magistrate,
Lordship.
then along with the forwarding report, you also give the grounds of his arrest, so that in one word, and therefore in the form, you'll always find grounds of arrest.
Yeah.
167 also it is there.
Yes.
Third line or fourth line.
It appears the investigation cannot be completed within the period of 24 hours fixed by section petition, and there are grounds for believing
Yes.
that the accused.
Same language is here in this police
Yeah.
manual.
Yes.
So grounds of arrest is relatable to this.
Yes. Lordship. Lordship, in my respective submission, Lordship, just to point out, Lordship, the object underlying the Article 22, Lordship, is that he gets an opportunity to be represented by an advocate, Lordship, or duly represented, Lordship. In that order also, Lordship, he was.
No, but now the Supreme Court has clarified. It has given
In right.
there are successive judgments
Lordship.
which says that this has to be scrupulously followed, and non-punishing of the grounds of arrest will be fatal.
Now, Lordship, if I may just be permitted to refer to this judgment, Lordship. This is 2025 768, Lordship. Kashi Reddy, Upendra Reddy, Lordship, is come across this. Just two paragraphs, if Lordship. 27 and 28. Twenty-seven, Lordship, is.
So there's one more judgment wherein the bench is Honorable Justice N. Koteshwar Singh.
Yes,
In that,
yes.
apart from concurring with the bench, he also gave his own
Yes,
behind global judgment.
own observations,
Yes.
where he has come very strictly
yes,
against the non-furnishing of grounds of arrest.
yes.
I understand that. Regarding section 47 and 48.
Just for my satisfaction, Lordship kindly produces 27 and 28.
Yeah, I've seen that.
Yes, 28 in particular, Lordship, for the purposes of clause 1 of Article 22, it is not necessary for the authorities to furnish full details of the offense. However, the information should be sufficient to enable the arrested person to understand why he has been arrested. The ground to be communicated to the arrested person should be somewhat similar to the charge framed by the court for the trial of a case.
I'll tell you why.
Yes.
29.
In that particular case, grounds of arrest are there, but in our case, there is no grounds of arrest. As per para 21 of death judgment, relied by Lanet PP.
Yes,
Bihan Kumar.
Bihan Kumar. Second part.
Yes, Lordship.
Lordship.
Yes, Lordship, I've gone through it. I've seen it, Lordship. Yes. Yes, I've read it, Lordship. Yes. Yes. Yes,
Specific charges have been explained in
yes,
that.
yes,
So we have quoted that also.
yes, I have seen that also.
So under the circumstances, we don't find we have to allow bail here.
Ultimately, Lordship, what has happened, Lordship, is that the ultimate purpose is that he needs to have the opportunity to be represented at the earliest opportunity, Lordship. That is within the 24 hours window, Lordship, subject to correction, Lordship. And it has been held in a number of judgments, including in 51 judgment also, Lordship. Some Atmaram judgment, I don't remember exactly. It has been held specific that the intention is that he should have the opportunity to be represented at the earliest. So here also, Lordship, if we go into all the technicalities also, Lordship, ultimate purpose is, Lordship, for that reason only, Lordship. It should not be that he is not aware of what he has been arrested for. Here, Lordship, it's a murder case, apparently, Lordship. And thereafter, Lordship, he was produced on the same day itself, Lordship, on 26/6, Lordship was seen. There also, Lordship, he was given the opportunity of free legal aid counsel. They declined and they stated that they want to engage their own counsel, Lordship. So my submission in that regard is, Lordship, that is sufficient compliance, Lordship. That's
It
all.
won't be interpreted in light of Supreme Court judgment.
Yeah, Lordship, yes, I am already.
You have a good point.
Yes, otherwise, Lordship, that judgment I was referring to, it is 51 SCC.
The section 51 of? Section 51 of? Which act?
No, Lordship, 51 SC, Lordship.
1951 Supreme Court.
Yes, I don't remember.
No, it's okay. We'll get it.
Vihan Kumar's judgment is very specific. On the failure to comply with the requirement of informing grounds of arrest as soon as may be after the arrest is vitiated. Once the arrest is held to be vitiated, the person arrested cannot remain in custody even for a second year, my lordship. By para 14.
It's okay. And there will be stringent conditions. Mr. N. New.
Rituraj Boiswa.
Rituraj?
Boiswa.
Boiswa, I'm sorry, I forgot. Then I counsel for the petitioner. Mr. Rituraj Boiswa and counsel for the petitioner. And Mr. B. Sharma, and conditional AP for the state. Next one. prayer for bail is made under section 483 of BNSS in connection with just say otherwise the petitioner Arup Das, who is facing trial in sessions case number 226 of 2024, which is pending before the Learned Sessions Judge, Kamrup Metro, Guwahati, in connection with dispute PS case number 645 of 2024 under section 302 of the 34 has paid for bail under section 483 of BNSS. Most of the petitioner has been taken into judicial custody on 27/6/2024.
Should be 26/6/2024.
26/6.
Yes,
Okay,
ma'am.
26/6. No, that will be not counted. From the date of remand, it will be counted. Judicial custody will be on the date when the remand made, 27/6/2024, last in letter 20, and accordingly, he has spent about so and so days in custody. Next para. The only ground on which the prayer for bail is made is that at the time of arrest, the grounds of arrest were not furnished to the petitioner. Which is in violation of the provisions of section 47. Now it is 47?
47 BNS.
47 of BNSS. In support of his contention, the learned counsel for the petitioner has referred to the case of Vihan, VIHAAN, Vihan Kumar versus State of Haryana and another, 2025, SCC Online, SC 269. Wherein it is provided that information of the grounds of arrest must be provided to the arrested person. Failing which it has been held that the arrest and consequent detention has been held to be bad in law. The learned APP has opposed the prayer for bail on the ground that the trial has already begun and two witnesses have been examined.
Altogether 7 witnesses
7 witnesses have been examined by now. Out of how many
out of
witnesses?
34.
Out of 34 witnesses. So accordingly, it is submitted that in view of the evidence which has already been brought on record, there is every likelihood that if released on bail, there is every likelihood of the petitioner that the petitioner would abscond. Full stop. So it is submitted that the purpose of providing the ground of arrest to a detained person as per Article 21 within bracket 1 of the Constitution of India is to enable the petition, the arrested person to appropriately instruct his advocate. Accordingly, it is submitted that once the trial has begun for committing murder, where the charges against the petitioner has already been framed, and he has been provided reasonable opportunity of defending himself in accordance with law. Release of the petitioner would not be in public interest. Full stop. In support of his opposition to the prayer for bail, the learned APP has referred to the case of Kasi Reddy, KASIREDDY, Upender. This is the one, huh? Upender Reddy versus Mansur. Text para. Though the submissions made by the learned APP carries weight, that in the meanwhile, the charge sheet has already been submitted and the trial has begun. However, it would be appropriate to put paragraph 21 of the judgment rendered in the case of Vihan Kumar within bracket Supra. Well, 21 and 28. Super. 21, 28. Which is a part of judgment authored by judgment rendered by Honorable Mr. Justice Abhay S. Poka, as well as paragraph 3 of the judgment of rendered by Honorable Mr. Justice N. Koteshwar Singh, forming part of the same bench. Yeah. इसमें page 39. Single bench. I'm sorry, 57. Next part. It is next part. It is also noted that in paragraph 36 of the judgment in the case of Kasi Reddy Upendra Reddy, in bracket Supra, while referring to, don't say 36, in the judgment of Pesadu Upendra Reddy, while referring to and following the decision in the case of Bihan Kumar within bracket Supra, it is mentioned that the grounds to be committed to the following Bihan Kumar, the following observations have been made. Para 27 and 28. Next para. The next para. In this case, the scanned copy of the records which have been called for from the learned trial court does not contain any material to show that the grounds of arrest was communicated to the petitioner. Under such circumstances, as per the judgment rendered in the case of Bihan Kumar within bracket Supra, comma, the arrest of the petitioner is found to be vitiated. So accordingly, is found entitled to bail. Next paragraph. As the trial of the offense under section 302/34
34.
is currently in progress, comma, stringent conditions are required to be imposed so as to ensure that that on grant of bail, comma, the petitioner does not abscond. So accordingly, it is provided as follows. Number one, that in the event the petitioner furnishes a bail bond of rupees 1 lakh with with 2 surety of like amount to the satisfaction of the learned sessions judge
Kamrup Metro.
Kamrup Metro Guwahati. And subject to submission of a bond that he would, that the petitioner would appear before the said learned court on each and every date of trial. And that on such dates where his absence is inevitable, comma, he would ensure that his duly represented by his learned counsel, duly instructed to cross-examine any witness that may be present in court. And to ensure that no adjournment shall be taken by the petitioner merely because of his absence or inability to attend the court. Comma, the learned, next paragraph, the learned Sessions Judge, Kamrup Metro shall accept the bail bond of the petitioner. Bail granted on the following terms. Next part, it is made clear that
One surety should be also government service holder also.
we are not saying that. If there are 2 surety, it will be enough. Just say that in the event the petitioner is absent on call on any date fixed for trial, comma, it would be open to the learned sessions judge, Kamrup Metro Guwahati, to issue a warrant of arrest to secure the presence of the petitioner for further trial. And on full stop, it is made clear that on the default in appearance of the petitioner before the learned trial court, comma, this order of bail shall stand lapsed due to default and would stand rescinded forthwith. So as to enable the learned sessions court to issue a warrant of arrest. Full stop. Anything I've forgotten? Okay. Bail stands allowed. Well, after a long time, I'm passing order of bail. I might have forgotten the form.
Tomorrow probably some cases are listed before also.
Or is it? I have to refresh my memory for bail or this. I think I missed out now.
No,